Welcome to the 13th lecture in this lecture series on international arbitration practice. We have been discussing various components of an arbitration clause in the last few lectures. In lectures 8 to 10, we had seen how to draft the main components of arbitration clauses. In lectures 11 and 12, we have discussed the aspects involved in drafting other components of arbitration clauses. In this lecture, we continue to deal with the other components of arbitration clauses. The subject that we would be discussing in this lecture is accepted matters. So, what is this accepted matter? If you are a lawyer in India, you would be familiar with typical government contracts which exclude or accept certain matters from the scope of arbitration clause. These matters are to be resolved either through court litigation or other methods of dispute resolution and are known as accepted matters. But it is common practice throughout the world to reserve certain disputes for resolution by experts. Such disputes include issues relating to valuation of shares, delay assessment, and technical issues or technical disputes. Let us illustrate these accepted matters with two examples, one typically found in India and the other found throughout the world. Situation 1. You are negotiating an agreement with your counterpart. While discussing the dispute resolution processes, you and your counterpart feel that you should give a chance of amicable resolution methods and agree for a multi-tiered dispute resolution clause with conciliation as the first step. You both are also in consensus that if conciliation fails, you should go for arbitration, but not in respect of all disputes which may arise. For certain disputes that are purely related to technical aspects, you would like to go for expert determination. Situation 2. You are a government body and you are drafting the tender document. While doing so, you state the conditions that would govern the contract with a successful bidder. You decide, along with your team, that you would not refer certain disputes to arbitration but to litigation by commercial courts. So, in these situations, you want to not accept, certain matters from the scope of the arbitration clause. How have such clauses fared? Let us have a look at some actual situations. An agreement provided in clause 2 for mandatory requirement of completion of contract within a specified time and for liquidated damages for failure by the contractor to complete the work within the stipulated time. This was in a construction contract. The agreement further stated, in the event of contractor failing to comply with this condition, he shall be liable to pay as compensation an amount equal to 0.5% per week as the superintending engineer, whose decision in writing shall be final, may decide on the said contract value. The dispute resolution clause provided the decision of the superintending engineer regarding the quantum of reduction as well as his justification in respect of reduced rates for substandard work which may be decided to be accepted will be final and would not be open to arbitration. The question before the court was whether the clause making the decision of the superintending engineer final accepted the matter from being referred to arbitration. The Supreme Court of India held that such a clause was final and stated, however, in respect of levy of compensation for the delay, clause 2 of the agreement specifically makes the decision of the superintending engineer final. The entire contract between the parties and the terms thereon have to be read as a whole to decide the rights and liabilities of the parties arising out of the contract. The finality clause in the contract cannot therefore be frustrated by calling upon the arbitrator to decide on the correctness of a levy of compensation by the superintending engineer. On the finality of the mechanism, the Supreme Court held the right to levy damages for delay is exclusively conferred upon the superintending engineer, and clause 2 of the present agreement is a complete mechanism for determination of liability, and when such compensation is levied by the superintending engineer, the same is final and binding. It is pertinent that the contractor claimed in this dispute that the liquidated damages levied by the superintending engineer was illegal. On this, the Supreme Court stated in claim number 6, the prayer sought for by the contractor to declare the compensation levied by the superintending engineer as illegal is contradictory to the agreed terms between the parties. So far as the liquidated damages determined and levied by virtue of clause 2 is out of the purview of the arbitration, especially in view of the fact that under this very same clause, the parties have agreed that the decision of the superintending engineer shall be final. This fact situation arose out of the recent decision of the Supreme Court of India in Mitra Guha Builders versus ONGC, a matter that was decided on 8 November 2019. Note that the clause provided that the decision of the superintending engineer would be final. It did not, for instance, prohibit reference of such dispute to arbitration in express language. Absence of such a prohibition could lead to disputes regarding whether the agreement sought to refer such disputes to arbitration or not. Fortunately or unfortunately, depending on whose side you are in, this issue did not arise in this case. So, if the intent of the parties is not to refer certain disputes to arbitration, that should be made clear and expressed in the agreement. It would be better to list out certain classes of disputes from arbitration if that is the intention. Importantly, it is crucial to mention how those excluded classes of disputes would be resolved. Some salient points that you must keep in mind while excluding certain matters from the scope of arbitration are given here. Let the coverage of disputes to be referred to arbitration be comprehensive. But if parties intend to provide for an exception, provide for an exception clause listing out the classes of disputes to be excluded from arbitration. Even if the agreement provides for specific dispute resolution processes for different types of accepted matters, it would be useful to comprehensively list them out in the exception clause. Ensure that the agreement expressly addresses how the accepted matters are to be resolved. In case those specific dispute resolution processes for the accepted matters fail, what would be the remedy? For instance, if expert determination is chosen for deciding an issue relating to valuation, what if after the valuer decides, what if the parties do not agree with the valuation report? Do they or any of them have the option of invoking arbitration thereafter? Let the agreement be clear on this. Importantly, ensure that one part of a class of dispute does not fall within one dispute resolution method and the other part of the same class of dispute does not fall into another. For instance, if liability for liquidated damages for delay is to be decided by an arbitral tribunal and the quantum of liquidated damages to be decided by a delay assessor, the dispute may not be resolved very easily. So keep these things in mind. Now we update our checklist to incorporate these salient points. Serial numbers 9 to 12 deal with the updated points. 9 says whether the excluded matters are listed out comprehensively in the dispute resolution clause. 10. Whether parties wish to provide for specific dispute resolution methods for these excluded or accepted matters. 11. Whether parties wish to provide for arbitration in case parties or any of them are not satisfied with the decision. 12. Whether the agreement provides for a resolution of an entire class of dispute through one forum rather than splitting the dispute resolution methods in the same class of disputes. With this, we complete this lecture. More on drafting other components in the next lecture. Bye bye. Stay safe.